Thank you very much.
you.
Good morning. May it please the court. Madam Chief Justice, my name is Tracy Rizzo, and I represent Raymond Eckersall. I would like to get back to the issue raised earlier about this appeal being moot. This appeal is, in fact, moot. The timeline of this case is as follows. The order at issue was entered on July 10th, 2013. The appellate court issued its ruling on May 28th, 2014. And then on June 9th, 2014, the final judgment for dissolution of marriage was entered in this matter. It wasn't until after the judgment was entered in this case that the appellant filed her petition for the PLA and on July 2nd, 2014, and that petition was granted on July 24th, 2014. The July 10th, 2013 court order was a temporary order. Therefore, it is no longer in effect because the final judgment was entered in this case. When a divorce action becomes final, the temporary order has fulfilled its purpose and is superseded by the final decree. In addition, pursuant to Section 501(d)(3) of the IMDMA, a temporary order terminates when the final judgment is entered. Therefore, the order in question is no longer in effect. It has been merged into the judgment for dissolution of marriage, rendering this appeal moot. There is no actual controversy existing between these parties. This court has held that an appeal is moot when it involves no actual controversy or when the reviewing court cannot grant the complaining party effectual relief, which is what we have here. This court has also held that it will not review cases merely to establish precedent. Counsel for Mrs. Eckersall has argued that the public interest exception should apply here and that this court should still hear this case despite the fact that it is moot. However, the public interest exception does not apply in this case. In order for the exception to apply, there are three strict factors that must be present in order for the exception to apply. The first factor is that the question presented must be of a substantial public nature. In May 2014, this court ruled in the case of NRA, the marriage of Donald B. and Roberta B., and this court held that the public interest exception did not apply in that case. With respect to the first factor of the exception, this court found that persons affected by Section 607E, which was at issue in that case, was a limited group of people. Despite the fact that this order has been used in Cook County for many years, there's still a limited group of people affected by this order. These orders are not entered in every case, as counsel has suggested. They are entered in custody cases in Cook County where the court believes that the parties are acting in a manner that's detrimental to their children, and they feel that they need to place conditions on the parties during their own time with the children. Because it's a limited group of people affected, it's Cook County primarily where this order is entered, and it's in cases that are really bad custody cases where the children are being affected. It's a limited group of people, and therefore the first factor to the exception has not been met. The second and third factors of the exception can be taken together, I believe. The second factor is there's a need for authoritative determination for future guidance of public officers. And the third factor is there's a likelihood of future recurrence of the question. The July 10th, 2013 court order was a temporary order, which, as we have discussed, has been a form order that has been used for many years in Cook County in the Domestic Relations Division. It's a temporary Band-Aid used to protect the children during the litigation. And despite the fact that this order has been used for many years in the division, it appears that this is the first time that such an order has been brought before the recurring court. Your honors have found in the case of Donald B. and Roberta B. that the statute being questioned in that case, Section 607E, was in effect for 20 years. Yet you noted that there was no reported decisions which addressed the application of the provision. The same is true here. Despite the fact that this type of order has been used for many years in the division, It appears that this is the first time such an order has been brought before a reviewing court. There is not a need for this court to issue an advisory opinion. The public interest exception is narrowly construed and requires a clear showing of each of the three factors. The factors have not been met in this case. I also want to spend a few moments talking what Mr. Rosenberg also addressed was the best interest of the minor children. This point, I believe, is the most important point that the court needs to take into consideration. This order was clearly entered to protect the best interests of the minor children. One of the purposes of the IMDMA, as defined in Section 102, is to mitigate potential harm to the spouses and their children caused by the dissolution of marriage process. It is evident that the sole purpose of the July 10th, 2013 court order was to mitigate potential harm to the children and to protect their best interests. That's the primary charge of the court, is to protect the children. It's the primary charge of the child's representative. These parties chose to participate in this litigation. The children did not. The conditions, which is what they were placed on these parties were reasonable, and they were placed there to ensure the best interests of the children. If you look at the order, as Mr. Rosenberg started pointing out, the conditions are really reasonable provisions. The parties cannot beat the children. The parties cannot drink alcohol in the presence of the children. The parties cannot allow members of the opposite sex to sleep over when the children are present. If a parent truly wants to protect their children during the litigation process, they would never dispute such an order. This order was drafted by Mr. Rosenberg. His charge is to act in the best interest of the children. The court who appointed Mr. Rosenberg cannot now be faulted for going along with Mr. Rosenberg's recommendations in protecting the best interests of the children. Thank you.
Thank you.